Welcome everyone to today's webinar, the new BIS 50% rule, what exporters need to know. Thank you very much for joining us. My name's Dave Noah and I am founder and president of Shipping Solutions. Since 1995, our export documentation and compliance software has helped thousands of successful exporters more efficiently generate accurate export documents and stay compliant with import-export regulations. To help educate our customers and the wider international trade community, we regularly host free webinars like this one on the various aspects of international trade. Today we are very lucky to have Lindsay Bernsen Wardlaw as our speaker. She is an attorney in the international trade practice in the Washington, D.C. office of Gibson, Dunn Crutcher. Lindsay is also an adjunct professor at the Georgetown University Law Center, where she teaches U.S. export control and sanctions law. At Gibson, Lindsay advises clients on compliance with U.S. export control, sanctions, anti-boycott, and customs laws. Before that, Lindsay was an associate at Sidley Austin and a vice president at Amelie Trade Compliance Consulting. Prior to law school, she was a corporate trade compliance manager, specializing in global compliance program building, process improvement, and system launches. So she knows what she's talking about. We've been very fortunate to have Lindsay participate with us in previous webinars and Ask Me Anything sessions, and so I know we can expect a very informative session today.
It is great to be here with all of you today. I'm going to talk about the new BIS 50% rule, also called the affiliates rule. So I think I want to start by diving into why you should still care about the affiliates rule, because as many of you have heard, the Trump administration announced that this rule would be suspended for 1 year as part of its tariff deal with China. So specifically, we have only this one statement that is official coming from the fact sheet for the China tariff deal, saying the United States will suspend for 1 year, starting on November 10th, we're not there yet, the implementation of the interim final rule titled expansion of end user controls to cover affiliates of certain listed entities. So first, you should still care because today is only November 5th. So you have at least 5 more days to be in compliance. 2, this suspension appears to be for 1 year from November 10th. That means it could snap back at the end of that year. You should be ready to implement the rule. Third, in fact, we know that the Trump administration likes to use all kinds of trade measures as negotiating tools, and it used this rule as a negotiating tool once already. We would anticipate then that it's possible that this administration could in fact use the rule as leverage if China were to not fulfill its end of its trade bargain, at least in the eyes of the Trump administration. So it could snap back even earlier. I wouldn't necessarily hold my breath that we will only see implementation of this rule in a year. Finally, the exact degree of the rollback of this rule isn't completely clear at this point. We only have this one bullet. We don't have a Federal Register notice. We don't have an additional fact sheet from BIS. So it's possible that this rollback will only be for Chinese entities and not for all entities that are covered by the rule. So for all of these reasons, I would hope that you pay close attention today so that you're ready to keep your program on track and so that you can comply until and unless the rule is in fact fully rolled back. So what is the affiliates rule? Well, on September 29th, 2025, BIS, the Commerce Department's Bureau of Industry and Security, announced this historic expansion of U.S. export controls that really push out existing entity-level controls, so end-user controls on particular parties, from parties who are enumerated on certain BIS lists to parties that are owned by, majority owned by parties on those lists, who are not themselves listed. So what we actually see is the rule constructively restricts transactions with unlisted affiliates of parties that are 50% or more owned, directly or indirectly, by one or more listed parties. Interestingly, right, this sounds a lot like the OFAC 50% rule, and that's why we've been referring to it as the BIS 50% rule. But there are some added complexities when you actually try to apply this rule in practice, and I know that's why all of you are on the line today. One of those complexities is the set of covered BIS lists that in fact roll down those restrictions to affiliates. So there are 3 lists that are captured, and this is not a comprehensive set of all BIS restricted party lists, only 3 of them. 1, the entity list. We know this is a list of parties to whom goods subject to the EAR may not be exported, but at an entry by entry level, there are granular restrictions on those parties in terms of the exact goods covered. Sometimes the entry covers all goods subject to the EAR. Sometimes the entry covers just some goods subject to the EAR. Sometimes there's a policy of denial of a license if you were to try to ship goods to that party. Sometimes there's a presumption of denial. A presumption is not as strong as a policy of denial. It's possible you can overcome the presumption of denial by convincing the government that you in fact deserve a license. Other entry by entry level distinctions might be that in some cases we see many affiliates directly listed on the entity list for any given party of concern, and sometimes we just see the headquarter company. And the affiliates rule kind of changes that scoping. We also have the MEU list. So the MEU list is a list of military end users in certain countries. There are also military end users now listed on the entity list, especially in Russia and Belarus. But the MEU list is not a comprehensive list of all MEUs that are covered by BIS's MEU rule. And we'll talk more about that later. It's a really small subset of all MEUs that BIS is concerned about. The last piece of this is there is not a formal list, but there is a set of OFAC specially designated nationals, so sanctioned parties, that BIS is concerned about. And in the EAR, in section 744.8, that's the end user control section, we actually see that BIS says for these very specific OFAC SDN programs or reasons for listing, we extend export controls to those parties to better implement our foreign policy goals. Those programs include the Russia and Iran programs, for example, but not all programs are covered. The Burma program is not a program that is covered by the EAR. So not every SDN is captured here. So let's look a little bit more deeply at how the affiliates rule works. One key concept here is ownership aggregation. And this one will feel familiar because it operates in very much the same way that ownership aggregation works under the OFAC 50% rule. And I'll show you a chart in a minute that kind of breaks this down and even compares the 2 regimes. So a foreign company that's owned 50% or more by one or more entities that are restricted under any or all of the entity list, the MEU list, or this subset of SDNs listed in part 744.8. That section, again, lists the programs that are covered, but not the parties. You have to cross-refer back to OFAC's SDN list to see the parties. Any foreign company, right, owned 50% or more by one or more entities restricted by one of these lists will be subject to the same export control restrictions as its owners. That sounds straightforward, except that the 3 lists impose different restrictions. Then the question becomes, which of those restrictions apply to me and my foreign affiliate that I'm trying to deal with? Then we get to the rule of most restrictiveness. For a captured unlisted affiliate, the most restrictive license requirements or license exception requirements or eligibility requirements or review policies applicable to any of the listed owners will apply to this affiliate. So basically, whatever is the harshest treatment of any of those owners will now apply to the unlisted affiliate. This is really interesting when we start looking at aggregated ownership, because this can mean you have an owner that is on the entity list and you can't export anything at all subject to the EAR to that party, and they're a 5% owner, but you have 45% owner that's an MEU on the MEU list. Well, now you've hit that 50% threshold. You're covered by the affiliates rule, but the most restrictive restriction applies. And so in fact, we can't send you anything subject to the EAR. The next principle here is that this rule, like the OFAC 50% rule, doesn't evaluate control. It only evaluates ownership. So you may be aware that in the EU, the UK, they look at control and the subject of their in the concept of their own financial sanctions 50% rules. We don't do that on our sanction side, and we're not doing it on our export control side either, at least not at this point. In the rulemaking for the affiliates rule, what we saw was that the US government was asking for comments on whether it should extend the rule to cover control. But for now, it was choosing to align with the OFAC standard, in part because that appears to be more administrable for industry if the two rules are parallel. The last concept I want you to know about, although it's starting to be a little bit less relevant, is temporary relief. So the US government authorized a carve out to the application of these rules, first through a savings clause, like we often see with BIS rules, for goods that were already in transit. That is to say that there was already an order and the goods had started moving towards their end destination. As of the day that the rule was released for public inspection, that was the 29th of September. The rule was actually published a day later, but it became effective on September 29th. So as of that day, if the goods had started moving and they arrive within 30 days of that day, they're covered by this savings clause. In addition, there's a limited temporary 60-day general license for transactions that involve certain less risky country group A5 and A6 countries, and their related companies, including JVs of companies headquartered in an A5 or A6 country. That temporary license expires December 1st, 2025. By that point, the rule may be fully rescinded, or at least rescinded for China. We're not really sure to what degree, right, per my earlier discussion. So the temporary general license may matter a little bit less prospectively, but may really have helped your business retrospectively. So how does this work? Let's really dig into an example. I think that these illustrations will help make it a little bit more clear as you're trying to do your diligence. Look, if you have 100% of your ownership divided into company D that owns your company E, your counterparty, and it has no restrictions available. So that's 50% of the ownership. We already have kind of evaluated, and that part's fine. Then we have company A, 30% of the ownership, and it's listed on the entity list. Company B is an SDN under one of the programs that is covered by 744.8, and it has 5% ownership. And then we have company C, which is listed as an MEU on the MEU list, and it has 15% of ownership. When we aggregate all of these ownership interests together, we come up with 50% ownership interest by restricted parties. So company E is in fact restricted, even though none of these individual companies owned more than 50% of company E. We aggregated their interest, and that was a problem. Let's take a couple of counterfactuals. If company B was an SDN under a different SDN program, like the Burma program, that wasn't covered by 744.8, then we wouldn't reach 50% of coverage by an affiliate rule list. And we wouldn't have to worry about flow down of restrictions from any of the parents to this party. There would still be this red flag because we have significant minority interest, ownership interest by companies A and C, but we wouldn't be prohibited from dealing with company E. Another counterfactual is if company C wasn't listed as an MEU, but our due diligence revealed that they likely were an MEU, what would we do then? Well, company C might still be subject to the MEU rule, and that might make us suspicious that company E is also an MEU subject to the MEU rule, just as a matter of our typical MEU rule diligence. But in that case, company C, because it's not on the MEU list, is not in fact covered by the affiliates rule, and so company E does not get to our 50% threshold. A little bit more of a deep dive. Let's say we have the same facts, but company B owns 50% of company B2. Company B2 gets treated by BIS in the same way that it would be treated by OFAC as a constructively listed party. And now we consider it to be 100% constructively an affiliates rule party that is now itself restricted, and it owns 5% of company E. So we go 30% A, 5% B2, 15% C, and we still come up with 50% ownership by restricted parties, where even though like a typical beneficial ownership review would say company B2's stake or company B's stake in company E is ultimately much less than that 50% of its ownership in B2, It doesn't matter. Once we've determined that B owns 50% of B2, B2 is treated as 100% constructively restricted, and then it has a 5% stake in E. This is a little bit confusing. I know that it is. And it's interesting to see how we got here. So in the OFAC 50% rule stake, I'm going to jump ahead for a second. There's an FAQ, FAQ 401, that really clearly draws out how we do this type of indirect ownership review and how we consider those intermediate entities to be 100% restrictively owned if the 50% rule is triggered. The BIS FAQ is significantly less clear. It says a listed entity X owns 50% of an unlisted entity Y, which in turn owns 50% of an unlisted entity Z. And then BIS says entity Z is subject to the same licensing requirements as entity X. We can only reach this conclusion if we assume that Y becomes 100% considered to be a restricted party as a result of its ownership by X. There's no other way to read this and reach the conclusion that Z itself is restricted. Otherwise, you come up with a conclusion that Z is less than ultimately 50% owned by X. I know that that's going to sound really bonkers and it's going to take some time to think through it. But the end result is company B2 in this example gets treated as if it's completely restricted, like as if it was on the list itself. And we then evaluate its ownership interest in that context. So how does the rule of most restrictiveness work? If we have company A and it's listed on the entity list with a policy of denial for all EAR subject items, and company B, which is listed on the SDN list with a presumption of denial for all EAR subject items, company C is subject to the most restrictive rule, the policy of denial for all EAR subject items. It does not matter that company A owns less of company C than company B does. That does not affect the analysis at all. If there's any amount of ownership and the rule is triggered, the most restrictive restrictions flow down. Another example. If company A is listed on the entity list with a policy of denial for all EAR subject items, but company B is listed on the entity list with a policy of denial for some EAR subject items, then company C, which they own together, wholly own together, is subject to a policy of denial for all EAR subject items, the more restrictive of the two restrictions. It doesn't matter that company A owns less of company C than company B does. This is where I think it gets really interesting. As we talked about, the entity list has different entry by entry requirements, and sometimes companies that are listed on the entity list are not subject to restrictions on all items subject to the EAR, just some items subject to the EAR. What if two companies or more own part of company C and they're each subject to partial export restrictions covering different goods? What then happens to company C? Well, it adopts all of those restrictions. So there's a policy of denial on company A for subset 1 of goods, and on company B for subset 2 of goods. Company C can't receive either goods in subset 1 or in subset 2. They can't receive any of those goods. So in most contexts, the most restrictive restrictions flow down, but in any case, all of the restrictions flow down. They stack. A few other things I want to make sure that we talk about with regard to the affiliates rule. One, the affiliates rule applies only to foreign entities. It does not apply to US companies. So if there's a US company that's more than 50% owned in the aggregate or individually by one of these listed parties, it still isn't covered by the affiliates rule. If it's a US person, it's a US person, and we're not going to consider it restricted unless it's directly listed on one of these lists. We've already talked about control, but while control isn't covered, indirect ownership is. That was the example I showed with company B2. Companies are required then, in dealing with their counterparties, to trace ownership all the way up to the ultimate beneficial owner to make sure that they understand if there is in fact one of these kind of indirect flows of entity list status anywhere in the chain that would affect their counterparty. And then the last point on this is that listed MEUs are covered, but unlisted MEUs aren't. And I've already kind of hinted at this. So there is the BIS military end user rule. It covers military end users in a certain set of countries: Russia, Belarus, Cambodia, Nicaragua, Venezuela, Burma. And in those countries, right, any party that appears to have this military nexus is considered to be a military end user. There's more to the rule than that, but that's the simplified way of thinking about it. And those MEUs can't receive certain goods that are in a supplement to the EAR. Their country restrictions for their countries that they're in also apply, and then this supplement stacks on top of those restrictions. Those unlisted MEUs, the ones that you find through your own due diligence, are simply not covered by this rule. Only the parties that are listed on the MEU list are covered, and then also those that are listed on the entity list are covered, because all parties on the entity list are covered. Two other points here under what is not covered. Other BIS lists are not covered. You might be aware of the unverified list, a list of parties for whom the US government couldn't confirm the bona fides. They couldn't confirm that these parties really existed where they said that they were located, or kind of what their line of business was. And so they won't grant licenses to these parties. Those parties are not captured by this rule. Denied persons who cannot themselves export from the United States, they're denied their export privileges. Those parties are also not captured by this rule. And then the last set of people that aren't captured by this rule are military intelligence end users. There's a handful of those that are directly listed in Part 744. They're also not captured by this rule. And finally, there are address-only entries in the entity list. This was a change that occurred a couple of years ago, adding parties in Hong Kong and then subsequently in the UAE and Turkey, adding these addresses to the entity list without a named party. So the entity list entry just has the country and then the address, no party at that address, because any party at that address is functionally covered. Well, in the context of the affiliates rule, because there's no party listed, the affiliates rule just doesn't apply. If you have a counterparty then who's at one of these addresses, that is itself, right, going to cause that party to be captured by virtue of the entity list. If it's owned by a party at one of these addresses, no restrictions adhere, but that's a red flag. You would want to double check kind of what the nature of that relationship was and if there was any diversion that could be occurring. So what does all of this mean for us? Well, there are a lot of things we're going to have to start thinking about. One, you may be aware that the US government publishes its International Trade Administration's consolidated screening list online. This list has the BIS lists, the DDTC, Department of State, ITAR-related lists. It also has OFAC lists. It doesn't have the CBP, like forced labor lists, but it has a lot of the US government lists that are relevant to us. That CSL is no longer going to be enough whenever you're thinking about whether a party is restricted. And really, it wasn't enough in the sanctions context already, because it didn't capture 50% rule liability on the sanctions context. But now it doesn't work even in the export context. And BIS really admitted this in FAQ 46, updated entity list FAQ 46, which it released in tandem with the rule. Instead, you're probably going to have to buy, if you haven't already, some type of third-party due diligence tool to help you determine whether or not your counterparty is owned by one of these covered parties on the entity list, MEU list, or one of the OFAC lists. BIS has also published this new red flag 29. It establishes an affirmative duty to verify your counterparty's ownership structures. And it basically indicates that if you can't figure out how your counterparty is owned, who owns your counterparty and in what percentages, you should be applying for a license to conduct that export. And if you don't apply for a license and then it turns out that this party was in fact a bad guy party, well, strict liability adheres, but this will also be an aggravating factor in your penalty determination. What I think is interesting here is that red flag kind of frames it as you need to know all ownership for your counterparty. I think it's probably enough to know 50% of the ownership of your counterparty, because then you know if the rule applies. We've already talked about advanced screening tools, but there's also this continuing problem that I think many of you have already seen in the OFAC context, which is that even with these ownership mapping tools that you could get, one, they don't always have the same information and they don't always come up with the same results. And so if you're comparing the results of different tools, it can be hard to decide where you have to keep digging and what you need to do. And I think if you have multiple tools, you probably need to consider the most conservative approach, but you can talk to your counsel about what to do in any given situation. Another approach is to have just one tool and rely on your one tool, and that's your process. And don't look at other sources of information besides your tool and what you can find online. But in a lot of these jurisdictions, if you don't have some type of tool where they have researchers on the ground who could go in and read the local language, you may not be able to find anything on your own. And that's because they have laws on the books, like in Russia and in China, making it harder for you to access this information if you're not a local, and or requiring companies or allowing them not to post information about their ownership, specifically to make it harder to comply with US law. So if you need to do this research, your best friend can be a company that is doing the research for you. It makes it a lot harder, though, to have a small compliance team, a small compliance budget, or kind of have a homegrown tool. So where do we see this heading? Well, again, this rule can snap back at any time, but certainly within the next year. When it does, right, there's likely to be a significant supply chain disruption. And you may have already seen this when you were thinking about the application of the rule over the last month. There was this really interesting analysis by a screening company called Wirescreen saying that in China alone, right, there were tens of thousands of companies that were captured by virtue of the affiliates rule that weren't actually listed. That is significant impact, and you would have a really hard time finding all of those companies on your own. So that disruption may make it very hard to continue sourcing some of the items that you want to source or continue contract manufacturing abroad. It may make it harder if China or Russia, or well, probably not Russia, but if China is just one step in your broader supply chain, you're sending goods there and then they're coming back to the US or going maybe to Malaysia, Cambodia, Thailand, etc. It just becomes significantly more difficult. You'll have to think about alternative supply chain paths if you're affected. There's also this risk of de-risking or overcompliance, where either your company, other companies that you know, or banks may say, sorry, this party isn't really captured by the rule directly. Maybe they have minority ownership by a listed party, but we're worried about the risk that we can't determine the full ownership, or we just think that perhaps there's more here that we can't really get visibility into. And so we're not going to deal with this party. So if you have a transaction party that it's legal to deal with, but your bank refuses to help you, you're still stuck. Alternatively, right, they could go out of business if other companies that are in your shoes choose not to deal with them, even if you're dealing with them and your bank lets you. So I think there's a lot of additional supply chain risk that way. We did see in the sanctions context, after Russia's invasion of Ukraine, that parties tried to circumvent the sanctions that were suddenly applicable to them by divesting the sanctioned party's ownership in a company that it had previously owned, by diluting their ownership stakes down to 49% or 48%. We might see something like that happening too, and then see kind of BIS playing whack-a-mole, trying to either directly list those parties or to think of how to extend the rule to those parties. And this might also be where we see control become an element of the rule after all. I should mention here, I said earlier that BIS said to industry it would take comments on adding control to the rule. It can do that because this rule is an interim final rule, which means that it is in fact immediately applicable, immediately effective, but BIS may change its form and in fact alter certain provisions based on comments from industry, which it was soliciting for 30 days from the day it was released, which ended at the end of October. Mitigation that your company could apply includes screening tools, we've discussed already, but you might also refresh your policies, your training materials. If you have end user certificates or templates, I think these are really going to be an area that you should look more deeply at. One, you may need to update their language to capture parties that are constructively covered. But two, if you have a large database of these EUCs or Some companies call them EUSs or EUDs. You have end user document statement certificates, and you've got this large library of them. And you've been for a long time saying these parties are not actually in my system of record, in my ERP, but I know that my distributor deals with them because of my EUC. You might have a lot of parties on those EUCs who are now captured by the affiliates rule, who will not automatically come up when you do rescreening with your updated screening system. Make sure that you're screening your library of EUCs to see if you have this risk that these indirect parties are in fact restricted. On that note, some of the screening tools that you may already have purchased have expanded their content list to cover ownership by parties on the BIS entity list, the MEU list. They already covered ownership in a lot of cases by these OFAC entities. You should be asking your screening provider to confirm that you now have updated content that will help you to comply with this list. That will make a huge difference. You may also want to be looking at updating your commercial agreements to reflect the new regulatory standards, doing that by asking parties, when you're asking them right now to represent that they're not owned by a sanctioned party, you're going to need to ask them to represent that they're owned by an entity list party, MEU list party, or in part, in aggregate, by one of these specific OFAC parties, even in an amount less than 50%. That is going to be really interesting because you could write that representation to say that you're worried about any party restricted by BIS at all. But in fact, we know that not all of the BIS lists are covered. The UVL isn't covered, the DPL isn't covered. So you might end up forcing your counterparty, right, to promise that it's not owned by a party that in fact legally it could be owned by. So think really hard about how you write those representations and update that language. And the last thing I would say is just make sure that where you think it, in fact, that one of your existing commercial relationships might be affected by this rule, that's where you want to go talk to counsel before proceeding. If it's prospective, you have some time to work it out on your own. But if it's already a relationship that you're in and goods are due to be shipped out any day, that's where you might want to seek legal help. There's one example I can give that I think is interesting of how this rule has already kind of reshaped global ownership structures, and that's Nexperia. This is a Dutch company. It's actually a Dutch semiconductor company that was in fact wholly owned by Wingtech Technology, which is a Chinese company that was on the entity list since December 2024. The Dutch government wanted this company to stay operational, and so it seized control of the company. It did this by transferring the voting rights of the parent company to this independent administrating body. It didn't actually change the ownership structure, and so the legal effect of this is unclear, but I think politically this is sufficient to get a license from BIS. And at the end of the day, this made Chinese government very angry. So China's MOFCOM actually retaliated at that point and said that Nexperia China and its subcontractors couldn't export finished components and subassemblies manufactured in China to this entity. So I think it's very, very interesting to see how this plays out. I think this is part of why we ended up having to walk back the rule. There were global implications that were much bigger than perhaps the Trump administration anticipated, or maybe it never really intended for the rule to have full effect and only wanted it as a negotiating chip. With that, I am open for questions.
Thank you, Lindsay. Very interesting presentation. Lot of things to consider, and I know that we've got some questions. So.
What does constructively listed mean? It's a question from Don. So constructively listed is a term that I'm using. It's not a term in the regulations, but it's a term I'm using to describe a situation where the party isn't enumerated on one of these restricted party lists, but is now captured by virtue of the affiliates rule. And it gets treated as though it is listed, except that if it has an aggregation of ownership, it actually is subject to the most restrictive restrictions or stacked restrictions. Using the term constructively listed can be really helpful when you have that chain of indirect ownership, because then you might have this party in the middle, like company B2, where otherwise you don't know how to refer to it, right? But in this case, it was owned by company B that was restricted more than 50%. So B2 was constructively listed, which then allowed it to confer its restrictions down to company E in our example.
If the rule does not apply to US-based customers, but we know they will re-export our products, would we still need to determine their ownership? And if we confirm that they are 50% or more owned by a listed company, would the responsibility to obtain a license fall on us as the supplier or on the customer as the exporter?
You have knowledge that this company is in fact owned by the restricted parties and would be captured by the affiliates rule, but for the fact that it's a US company and it's going to re-export. It really depends on who it's re-exporting to. So it's not directly covered. If it's re-exporting to a party that is covered, then you may have to apply for a license. If it's not re-exporting to a controlled end user destination, you do not have that obligation. So it's about what you know about what they're going to do with the item, but they themselves aren't restricted. So if they are not sending it to a restricted end user or a destination, you do not have to apply for the license. If you have the knowledge that they are, then you might have to.
I know you talked about this already, but can you repeat it, please? Can you explain postponing the BIS affiliate rule, 50% rule for 1 year, and will it only apply to Chinese companies?
That is such a very good question. And the problem is that we do not know the answer. What we have is this one bullet from the China deal fact sheet posted on whitehouse.gov saying that the rule will be suspended starting November 10th. So not suspended yet, and it will be suspended for 1 year. We do not know if it only applies to Chinese companies or if it's the entire rule being pushed back for 1 year. And moreover, frankly, we have reason to doubt that there will actually be a 1 year delay because this administration likes to continue to renegotiate trade issues indefinitely until it gets the results that it wants. So it may pull back the rule sooner.
Keep that in mind as you plan going forward. Are there de minimis exceptions to these regulations?
There's not a formal de minimis exception to this regulation, but there are de minimis rules in the EAR more broadly that still apply whenever we're thinking about transactions with these parties. So if goods aren't subject to the EAR, then you can send them to parties that are captured by virtue of this rule, to a constructively listed party. That's because when goods aren't subject to the EAR, you don't have to follow the EAR. Generally, the US person, like if you're a US person, there are still some rules that apply to you as a US person. Like you can't support nuclear, biological, chemical end uses, etc.
Can you give an example of different types of EUCs?
Yeah, so there are different ways to frame EUCs. These are end user certificates that I mentioned earlier, and companies sometimes call them different things, end user statements, end user documents. The most effective way to write an EUC is to require your counterparty to affirmatively state how they will use the good. That way you can check on whether that's an acceptable end use. And then I also like to ask them to state in the negative, I will not be using this good for military use if that's prohibited for them. I will not be using this good for chemical, biological weapon end use or for any of a number of other restricted end uses, like in China, a semiconductor manufacturing end use. Tailoring those end uses to the end user can make for a shorter certificate, but if you have a lot of possible end uses for your product, maybe you have to list all of them. But you can just have that negative statement. I won't be misusing the product, basically. I won't be applying for end uses that are not permitted under the EAR. But I think it's a lot better for you from a due diligence perspective to find out what they will be using it for and to hold them to that.
And would you revise those end user certificates to request a list of ownership and ownership percentages?
If you don't think that you can find out ownership and ownership percentages on your own through your due diligence tool or your due diligence team, I think that's a reasonable thing to ask for, and companies will understand why you are asking. They still may not want to provide this information. So you may decide that you only want to employ an EUC in certain risk-based situations. Maybe it's not possible to get an EUC from every customer, and that might really delay business and bog down your trade team to review all of those EUCs. So maybe you only ask for them when you're shipping to certain countries like China. There are countries that I think are higher risk from the perspective of this rule, right? most entity list parties are in China or in Russia, although most of you can't do business in Russia right now. There are also countries that are subject to the MAU list rule, right? That's going to be, I mentioned them earlier, right? Russia, Belarus, Cambodia, Nicaragua, China, Venezuela, Burma. Those countries are also higher risk. Maybe you only target your EUC to companies based in those countries. There are ways to do this that may not be as burdensome.
But your example of the Dutch company kind of indicates that isn't 100% going to protect you.
That's right.
If a U.S. Origin temperature recorder classified as EAR 99 is shipped by our supplier in Japan, along with Japanese origin products to a foreign party, either as an in-country transfer within Japan or as a re-export to another foreign party, is the foreign exporter / supplier responsible for determining ownership under the BIS 50% rule?
I think the answer here is going to be generally yes. This is like the question we got a moment ago. It all depends on what knowledge you have. If you know that you're selling to the Japanese party, but you don't know if they are sending it on or who they are sending it on to, and you don't have any red flags suggesting they're sending it on to a party that would be restricted, then they're the ones that have to determine what happens next because they're taking that next step of continuing to export the product. And because your items are subject to the EAR, they have an affirmative obligation to follow the EAR and determine whether or not that counterparty is subject to the 50% rule.
Okay. There's a few questions asking, do you have any recommended screening tools to comply with this affiliates rule?
There are a lot of really good tools out there. I am aware because I was told personally that the Dow Jones tool now has content that covers ownership by an MEU list party or by an entity list party, and of course already covered ownership by all of the OFAC SDNs. I also believe, although I haven't personally confirmed, that Caron, Sayari do the same thing. The other place that you might look, there's like a little bitty company that's a startup that has very cheap screening services called Byte.io. I had talked to them a couple of years ago at a conference, and they offer screening services that cover more than just the US list. They also cover foreign lists. I'm not sure they would cover ownership, but if you're currently only relying on the CSL, that might be a good way to start branching out because they do audit logs and they're very inexpensive.
Okay. Shipping Solutions, of course, has its own screening tool. Our screening tool includes the Dow Jones list, but does at this point we're still working to enhance the screening that it does to comply with this tool. So if we have an existing order about to ship that is captured by the affiliate rule, can we rely on the fact sheet statement that it is delayed and proceed, or will something official be published before November 10th?
I don't want to speculate on whether something official will be published before that. I think it's really unlikely that this administration would enforce against you when it has already said that it will not be it'll be suspending this rule as of November 10th. I definitely wouldn't take action before November 10th, though. I would wait until at least that effective date, see what happens. But if there's nothing more official than the fact sheet as of November 10th, I think the likelihood of an enforcement action against you by this administration as of that date is very, very, very slim. Even if they later come back and say, actually, sorry, we decided that we were going to enforce this rule after all.
Is the freight forwarder under obligation to do due diligence as well?
So ultimately, responsibility always lies with the exporter, and it cannot be given away to the freight forwarder. Freight forwarders, though, there was this really interesting FedEx case about export compliance responsibility by freight forwarders. They do have their own independent responsibility when they're moving the goods. If they see red flags, they may not know the contents of the goods, so they may not always be able to determine an exact export control analysis. But if there are red flags that something's going to a restricted party or an embargoed country, they do have to take their own measures to try to be compliant. But that doesn't excuse any responsibility on your part, and they don't really have to talk to you about it.
Okay. Besides exporting and deemed exports and contracts, we've identified that this updated rule will potentially impact our visiting scholars program and some collaborations. Are there other areas you can think of in a university setting where this rule could have an impact?
So I assume when we say the visiting scholars program could be affected, it's because their universities are restricted. Individual people, right, wouldn't be affected by the affiliates rule because there's no ownership concerns there. Um, I do think that laboratories at foreign institutions, so if you're collaborating with other foreign laboratories, that could be an issue for you with regard to the technology that you can share with those laboratories or prototypes that you can ship to them. Um, that doesn't seem infeasible to me. Likewise, if you're coordinating with a party, perhaps that would be considered to be a military end user because it's like a defense university, a defense laboratory, that might be affected too.
We export raw materials that we know will be resold after integrated into other materials. How far do we have to go down the supply chain to determine the ultimate end user? Our items are EAR 99.
This is a question you won't be surprised actually that law firms hear not infrequently. Um, it's not one that is clearly answered by the regulations. At the end of the day, your obligation is to act on the knowledge that you have. There's strict liability for what you export, regardless of the knowledge that you have. But if you have knowledge that a good is going to a bad guy anywhere indirectly down the line, then you also have a very specific obligation not to allow that transaction to occur. While the government employs strict liability that might apply even if you don't have knowledge if a bad guy were to get the good, it's very unlikely they would enforce against you if there's an attenuated relationship to the end user and you didn't have knowledge that they were in fact involved in this chain. So it's kind of a mixed bag. One, there's always liability for whatever happens to the good that you export, but it's not actually very likely to result in an enforcement action against you unless you have the knowledge of who the end user is. And there are specific prohibitions when you do have the knowledge.
Are there any specific products that this rule has targeted, or does this new affiliates rule apply to every exported product regardless of license requirements?
It applies to every product that is subject to the EAR. If the end user is now constructively covered, it applies to any product. But what you'll see is because the restrictions in the EAR against some of these parties are granular, it really only applies to the products for any given counterparty. It applies to the products that are restricted to that counterparty's owners as they flow down. So what I mean is if your counterparty is more than 50% owned by an MEU list party, the restrictions that flow down to it are not to send any goods listed in supplement number 2, which is the list of mostly unilaterally controlled goods that are otherwise pretty lowly restricted, to that party in China, like the MEU list countries that I described earlier. But nothing else will be restricted to them. But any product theoretically could be restricted to any of these parties depending on which restrictions flow down based on their ownership. Does that, David, I want to just kind of gut check with you. Does that sound, I know that it's right, but does that make sense the way that I framed it?
Yep, I think so. Is it possible to get a link or a paper on the FedEx case that you referred to? Is there some kind of a reference that you have? If you will forward that to me or a link of that to me, we will put that on the resources page for this webinar. So we will include a link of that on the follow-up materials that we send out. So keep an eye out for that. Good question, and thank you, Lindsay. The DoD published section 1260H, Chinese military operates in the U.S. Does the BIS 50% and MEU apply?
This is such a savvy question. It's something that comes up a lot. The interface of these two rules is kind of confusing, just even thinking about the MEU rule before the affiliates rule and section 2060. So these Chinese military industrial companies or Chinese communist military industrial companies that are in 1260H, there's no official restriction on them under the EAR. But that list of companies tells us who the government thinks of as being military parties in China. And so to me, that informs our due diligence when we're trying to research who is an MEU under the MEU rule. But the 1260H parties are not covered by the affiliates rule unless they're also on the MEU list, right? There's the MEU rule, which covers parties you find in your own diligence and parties on the MEU list. The MEU list is all that matters for the purposes of the affiliates rule. So the 1260H party, I don't recall if it has overlapping parties with the MEU list. If it does, that those parties are captured by the affiliates rule. Otherwise, that's helpful information for thinking about complying with the MEU rule more broadly, but doesn't matter for purposes of the affiliates rule.
What is the risk of secondary sanctions if I supply critical items that are not subject to the EAR from foreign countries to entities that fall under the affiliates rule? Will I end up on any of the BIS lists myself?
Yeah, so BIS wouldn't use the term secondary sanctions, but to your point, could you be put on the entity list for dealing with one of these parties, even if in fact the goods that you're handling are not subject to the EAR? I think yes, you could. I think that's a way that the entity list could be used to stop sales that are otherwise permissible to these parties that the US government doesn't want to see. And I think it depends on the volume of goods that you're sending and the degree to which sending them furthers foreign policy interests that the US government doesn't like, whether or not you in fact become listed.
Okay. Are we allowed to import from the companies that are captured by the 50% affiliates rule?
Also a really savvy question. Look, the EAR generally doesn't restrict imports at all. And so the answer is mostly yes. But if you're being really kind of careful and thinking about how your transactions with these parties might play out, what if you export something to a customer who's captured by the affiliates rule and it breaks, it's defective, they have to send it back to you? Well, like that's going to be, sorry, I framed this hypothetical backwards. What if you bought something from them, it's defective and you have to return it? You cannot return it to them. That's an export. What if you are trying to manufacture something to spec, and so you're planning to import goods from this party and that seems like it should be fine, but you send them specifications to make your good? That's technology under the EAR. So if the technology was captured by the EAR, you couldn't send that either. So there are reasons to think that you should be really cautious in importing from these parties, even if you could. The other piece of this I would say is it's not the EAR, but there are these ICTS restrictions that are also administered by BIS, where there are supply chain restrictions on the import of certain items like connected automobiles and their hardware. We're going to see more and more of these supply chain restrictions get rolled out. And so I would expect that in some cases where you could import from parties on these lists, they are subject separately to ICTS restrictions that would stop you from doing so. So you're going to have to be aware of those ICTS restrictions too.
Can you give me a little update on how the enforcement of the OFAC 50% rule has been handled, and if that has any lessons for an enforcement under the BIS 50% rule? Is that too broad of a question?
Pretty broad question. OFAC does enforce transactions with parties that are listed on the 50, that are captured by the 50% rule, but are not in fact listed on the SDN list. It does this very frequently. A lot of disclosures and investigations relate to transactions with parties that aren't listed that are captured. I'm having a hard time thinking of a case off the top of my head, David, but I know that it happens frequently. And so I would expect it to happen frequently here as well. And in fact, BIS did some really peculiar things in issuing this rule, right? It issued it as a final interim rule. It issued it where it was effective the day before it was officially published. It did things that created a sense of urgency in rolling out the rule that suggest it really wants to enforce this rule. That said, it's now paused, but I think that we should take away from this that when the rule does in fact go into effect permanently, BIS is going to be serious about enforcing under this rule.
Okay, well, that's a good, I think, final answer for today's webinar. we've reached the end of our time here. So I want to thank you, everyone, for attending, and I especially want to thank you, Lindsay, for this information. You were literally updating your presentation right up to the very last minute because it's such a new rule and certain things about it are still unknown. So thank you for your willingness to share your knowledge and experience with us. As I mentioned before, we've also created a resources page on our website that includes links to the resources that we mentioned today, and we'll add that link for the FedEx settlement on there as well, so you can see information about that. You can get to that resources page by following the link on the slide, or you can use your phone to take a picture of that QR code, and that'll take you there as well. Please also check out the Shipping Solutions YouTube channel. We've now published more than 300 basics of exporting and importing videos on our channel, and these continue to attract a growing audience, which we really appreciate. And if you find these videos to be helpful, please consider subscribing to our channel. So I think that's it. I want to thank you again, Lindsay, for your excellent presentation, and I want to thank everyone who joined us today. And if you have any follow-up questions, you can always email me anytime, and you should be getting emails from me, and you can just reply to those and I'll get those. So thank you, and please stay well, everyone.